I want to talk now about some of the disadvantages of bankruptcy. As I indicated, the last step of an actionable strategy for surviving financial crisis is making sure that you're determining whether or not you even need to file bankruptcy in the first place. The starting point for that, to me, is to really talk about what are the disadvantages of bankruptcy. The first disadvantage is that every aspect of your financial affairs will be scrutinized. So if for some reason you have irregularities in your banking, you have irregularities in your tax filings, chances are those irregularities are going to be discovered during your bankruptcy, and if they are discovered, you can be subjected to criminal penalties or civil fines as a result of those irregularities. So every aspect of your financial dealings for many years past are potentially going to be subject to scrutiny by government or people who are working on behalf of the government. Typically in bankruptcy court, you're dealing with the bankruptcy trustee. You rarely see a bankruptcy judge unless there's litigation in your bankruptcy, but you will definitely see the bankruptcy trustee. The trustee is essentially an attorney. Sometimes a trustee is a law firm that's been appointed on behalf of the court to ensure that the bankruptcy estate, and the estate is everything that you own, including your debts. The bankruptcy estate is administered properly so that you are treated fairly and the creditors are treated fairly. And put it another way, to make sure that you're not keeping things that rightly should be sold for the benefit of creditors. So the bankruptcy trustee is responsible for that, and to make sure that the rules of the bankruptcy court are properly executed. So if there's anything going on in your finances that's troubling, chances are it's going to be discovered. I've told people many times, don't try to get cute and not include an asset. The stories abound of people showing up at bankruptcy hearings. They call them 341 hearings. That's when you usually your first foray into the court, and you're there and you're meeting with the bankruptcy trustee. It's called a 341 meeting of creditors. And sometimes your creditors are also there. Sometimes they'll come to the table, represented by their attorneys. And let's say, for example, you're wearing a very expensive ring that somehow or another did not find its way on your schedules. Well, you might be questioned about where that ring comes from and why is it not on your schedules. Again, any aspect of your financial dealings and what you own and who you owe, who you paid off, a year or 6 months prior to filing, could be something that would be asked of you in a bankruptcy. And you're not able to avail yourself of the advice of counsel defense, meaning my lawyer told me to do this, to manage my affairs this way. The advice of accountant defense, my accountant told me to manage my affairs that way. You're not going to be able to avail yourself of those defenses in bankruptcy. Anything that you've done with regard to your finances or your debts is going to be potentially scrutinized, and again, there are penalties if irregularities are discovered. Second, a bankruptcy can be reported on your credit report for up to 10 years. That's usually a Chapter 7. A Chapter 13 is usually removed after 7 years. So, for many years after you receive a discharge, you're still going to have that bankruptcy looming on your credit report. So, you may have emerged from bankruptcy. You're a much better financial planner. You got a new job. Things are different for you. And then 4 or 5 years into your successful reemergence from bankruptcy, you're still having to answer questions as to why you filed bankruptcy, and then kind of having that stigma of being a bad credit risk on you. So you have to know going in that mark, if you will, on your credit is going to remain there for up to 10 years in a Chapter 7 and about 7 years after reemergence from a Chapter 13. So that is a concern as well.